Welcome to tonight's edition of Behind the Headlines on yet another very good day. It is the 20th of October in this year, 2021. Welcome and thank you so much for choosing to be with us. Now, just let you know that the conversation that we're going to delve in this very evening is one that is gaining traction and, of course, increasingly becoming very contentious. And this is the issue of bail in this country. Now, for as much as I can remember, the discussion and the talk about bail in this country started as early as March 1987. President Yoweri Kaguta Museveni visited and spoke to the Uganda Law Society at the time. He gave his opinions and what he thought about bail. I just want you to listen to this, watch this, then we get into our conversation and discussion this evening. My name is Gyagenda Semakula, sitting in for my senior comrade and colleague Charles Odong-Tho, who is not with us in studios, and he's where we are.
Recently, I had a very interesting case. One old man had his cows had been stolen by some other person. Then eventually he found the cattle. So they were taken to the police station as exhibit. And being taken to police station as exhibit, they are put there in the town, you know, to stay feeding on the cassassery in the town. Then the man, the thief of the cows, was released on bail. So this old man came and asked me, who has committed the crime, the cows or the thief? You see, because according to him, the cows were in prison, they had been imprisoned. And the thief was at large. So it could not make any sense to this old man. And I could not.
Well, thank you so much. Now, that was March 1987, and of course, that's the time President Yoweri Kaguta Museveni started his spirited fight for or against bail, as we'll get to know much more. Welcome to our conversation tonight. Joining us in studios today is Professor Gyagenda Latigo, the first and former leader of the opposition. You're very welcome, Professor Gyagenda Latigo.
Thank you very much, and good evening, viewers.
Thank you very much, Professor Gyagenda Latigo. Now, of course, together with Professor Gyagenda Latigo is Dr. Lilian Abel. She is the woman member of parliament for Kitgum district. Welcome, Lilian.
Thank you very much, and a good evening to you, viewers.
Well, thank you very much. Together is Mr. Alex Waiswa Mufumbiro. He's the head of training, patriotism, and the deputy spokesperson of the National Unity Platform Party. Welcome, Waiswa Mufumbiro.
I am very humbled to be here today to this very important national discussion on bail.
Well, that's very good. And of course, the usual and everyday panelist, Sarah Birete, the Executive Director of a Center for Constitutional Governance. She's a regular here and always here. Sarah, welcome again, and thank you so much for coming.
Thank you, and good evening, viewers.
Well, that's very important. Now, we were expecting to have Fiona Wall-Nabasa Gladys at the current president of the Uganda Law Society, but Fiona is not in position to join us, and she will not be with us tonight because of health issues, but we pray that you will be fine, Fiona Wall, wherever you are. And of course, to my brother Charles Odong-Tho, who is also not here. Now, this conversation is live right on UBC TV and of course on all our the social media platforms. You can follow us. Hashtag is UBC Behind the Headlines, and of course, our Twitter handle, Facebook, YouTube, and all those. Follow us, and of course, we'll be sharing the number with you for which you can follow us and also participate today. As we seek to answer justice in the face of the proposed bail reforms. Very welcome, and of course, now here is where we are talking about bail. I think I will just get to Dr. Lilian Abel to set the ball rolling and to open the stage for us in these issues. Then we get to the thoughts. Welcome, Lilian.
Thank you very much. I want to thank my fellow panelists and begin with saying that the issue of bail is not a new discussion. It has been there, and what might be seemingly to be seen as new is the issue of the amendment. But the issue of bail is captured in the 1995 Constitution the Republic of Uganda. Article 236 captures issues of bail. The issue of the Magistrate Court Act, Section 75, 76, 77 up to around 82 captures issues of bail. The issue of the Trial on Indictment Act, Section 23, section from 14 to around 23. So we capture all this already. But the question is, why is the executive arm of government thinking of an amendment at this time? Of course, all the laws put in place is meant to create some sort of order in the community, and is meant to, create a deterrent and prevent people from, doing things that will create disorder. So the issue of bail, first of all, bail itself is not a right, but everybody has a right to apply for bail. But it's upon the discretion of the magistrate or the judge to grant bail. And everybody can only be guilty, neither guilty nor innocent, until proven by courts of law. So there's been a recurrent challenge of cases, criminal offenses, happening in our society. And the culprit seems to be going hands-free. Somebody is known to have defiled an 8-year-old girl, maybe to a point of death. But because you can't prove, people know, and the suspects or the suspicions all point at that person, but you cannot prove it. And the courts of law is taken advantage, and before you know it, the person is even there attending burial with the people. Sometimes this has led to people taking laws in their hands, and you've had cases that people have been killed, somebody has been murdered, mob justice, because they feel like the law has not taken its course. There are cases that people have been arrested and have been granted bail, and people go ahead and defy. They take advantage, and somebody doesn't report back. There are even cases that those who have been released on bail have still been tried after. So, as a government, the executive arm of government, or the president, is trying to look for solutions on how you can address these cases. Someone has been defiled, there is nothing being done about it. You can buy your way out. Somebody has been murdered, and people are crippling in pain. Or somebody has been suspectedly to have murdered someone. So if that person is given protection and say, don't first go into the public, you need to give room for investigations to be done.
Okay.
Before.
Lillian, hold it here. I will come back to you later, but I'm also just now remembering that it was, I think, in 2018 when you were appointed on a committee that was supposed to be headed by, I think, Professor Chidumakuya, a constitutional review committee. I remember about something in this country. I do not know what it is, but I think we'll come to that, and also know from you whether
the committee didn't take place.
The committee didn't take place. Yeah. Yes. Okay, it didn't take place, and of course, I would just love to know whether these are some of the things that we'll be capturing. Sarah, let me come to you. We talk about bail. Now, we know very well that legally, if there is something that we can't ably interpret, it creates a vacuum, it creates loopholes it creates some ambiguity in it. And this is bail, for example. Do we even know what bail is? Because we talk about bail, which to some people is construed for acquittal in a way, especially the Wananchi. What is this bail that we're talking about?
Well, bail is temporary relief or release by courts of law when a person is accused of committing a crime. Under common law principles, bail serves the function of preventing pre-trial detention. Sorry, I think challenges with my mask. Pre-trial detention. The African Union Commission on Human and People's Rights has gone ahead to enact guidelines that are supposed to prevent pre-trial detention in Africa, and these guidelines were adopted in Rwanda in 2014. Uganda discussed and adopted these guidelines. And this is in addition to the so many international protocols and instruments, including the Universal Declaration on Human Rights in Articles 7, 8, 10, and 11 that provide for presumption of innocence, non-discrimination under the law, right to a fair hearing, among others. The principle of presumption of innocence, as provided for in our Article 28, Clause 3 of the Constitution, is a key principle under common law. The opposite of that is the French law, which is you are guilty until you prove yourself innocent. So once you have the principles of non-discrimination under the law, equality under the law, presumption of innocence, right to a fair trial, personal liberties as provided for in Articles 23, 28, 24 of our Constitution. And then you have this debate. These same principles are enshrined under the African Charter on Human and People's Rights, as well as the East African Treaty on the democratic principles. So as we hold this debate, I think Cabinet should be mindful of the Geneva Convention on Treaties. And if you were a signatory to an international instrument that you have signed, did a depository of instruments, ratified and domesticated, is there room for withdrawal from some of these provisions? So as we debate this, I think in the hindsight, I would have expected that by now, Cabinet is thinking of whether they can express reservations on these regional African Union and international treaties on the debate they are fronting, because we have already domesticated. These are all domesticated under Chapter 4 of our Constitution. So if we want to express reservation now to the Universal Declaration on Human Rights, which is commonly known as the International Bill of Rights, because this debate, if you are saying some people are not equal under the law depending on the offenses they've committed, you are talking of a reservation on Article 7 of the Universal Declaration on Human Rights on equality before the law for all persons accused or suspected of committing crimes. If you are talking of a presumption of innocence and the right to a fair hearing, which will need amendment, part of it on Article 28, you are talking of Articles 10 and 11 of the Universal Declaration on Human Rights. So under the Geneva Convention on Treaties, of which we are signatory to, what does it say if a country deviates from some of these international provisions that were already domesticated? You know, it is easy to sit here and say, this is our constitution, we can amend it. But there are implications. So, and expressing reservations takes time. You can express a reservation on a provision of an international protocol that you have ratified. It normally takes 2 years for the member states to discuss your reservation and then withdraw in the general provisions of most of the treaties. And this is the standard treaty provisions. So as we debate this, it is not just a Uganda debate. We are tampering with the International Bill of Rights. But I have seen comments, you know, the controversy on bail, away from the international challenges that are going to further dent Uganda's image, which is already dented in terms of human rights. So this is going to further escalate the image, the denting of the image of Uganda in terms of institutional arbitrariness under the interim regime when it comes to human rights violations.
Okay.
But I wanted to say two things.
To set the...
Yes, before you bring in briefly, the controversy on bail. When did it, you said it began in 1987,
For as
but
much as I
after,
remember.
yes, after the enactment of the 1995, because the Constituent Assembly resolved that debate, and I've seen the response of Justice Odochi saying it is not him. He only recommended to CA because there was some blame apportioning to him. You know, our Constitution has 3 godfathers. 1 is deceased and 2 are living. So the 3 godfathers of our Constitution, President Yoweri Museveni, the late Wapakaburo, who steered the Constituent Assembly, and then Justice Odochi, who steered the constitution-making process. So we have 1 deceased godfather, and the 2 godfathers are now contradicting on bail. But briefly, in 2005, the first attack on High Court, our Temple of Justice, by the Black Mamba after bail was granted to Kizza Besigye and 22 others, I think was the first real attack on debate on bail after the enactment of the Constitution. The 2 were granted bail by Justice Rugaiza and then rearrested and charged in the court martial the next day. That controversy was resolved by Justice Ogola in what he termed as temporary bail granted to Besigye and 22 others, and later the Constitutional Court pronounced itself on the right to bail, the discretion of court, and how bail should be granted in this country. So we have had a test of this bail to the extent that the Constitutional Court has already pronounced itself, and nobody challenged that decision when they granted finally bail to Besigye in that controversy.
Well, that's very important. I think we'll come to that, Dr. Kizza Besigye's case and what the court actually ruled to that, because I think it gave a very good interpretation to Article 23, which has all these bail issues in our constitution. And I think we also need to get to this. But we also need to set the record straight to know. What is government proposing? What is the executive proposing? Is it to scrap bail from our constitution, as it is said, or President Museveni's idea or opinion of a deferred bail, or not even having easy access to bail because of the syndrome of recidivism and impunity that also emanates from bail? I think this also needs to be set straight. Are we talking about scrapping a bail from our judicial system, or we talk about something different? And I think this needs to come out very clearly. Before I come to my brother Waiswa, who was not here actually in 1987, I'll go to Professor Gangala Tigo, definitely was here.
Bring that out clearly.
Yes.
What, from the point you've mentioned, the issue is not to scrub off bail completely. No. The issue is there are some cases, criminal cases, like murder, like rape, defilement, the robbery. These are cases which has been rampantly reported, and there seems to be very difficult ways on how to address them in the society. Okay. And this is a call from the side. So we are saying there must be a way to cap. You know, anything to do with the law is to cap and control the society.
Okay. Professor Ogenga, please come to the conversation. Let's talk about these issues. And of course also seeking to know whether this is purely a legal debate, or we are extending this debate to the social sphere.
Well, thank you very much, and I thank my 2 sisters for their contribution. I mean, you know, that we are talking about the bail issue, and you read about the justification as given by the Attorney General and expounded on in the national debate. I just feel sad for our country, because I don't know whether we realize the import of what we are doing. That we are even debating the issue of bail. I would want to ask government, is there any place where the issue of bail has been controversial anywhere in Africa in the way ours have been? And the problem, which is very straight, and you started it well, consistently it is the position of the president. Is this country about the position of the president, or what needs to be done so that the country runs well? I am, to be honest with you, I'm very disappointed.
That we're discussing bail?
Yes, because we are trying to justify, and I could see my sister Lillian striving to bring the government position, my sister Sarah bringing this international context. But me, I would just take it back as an elder and say, if a dad comes, says, this boy is very stubborn, for this reason, everybody will not leave home from 6. Should the stubbornness of one child be the reason why you should impose your will on the home? And this is what is happening. So we can discuss the technicalities, but the simple thing is a crime, judicial process, bail, whatever. There are a totality of things. Talk about it all. It will include investigation by the police. Talk about that. It will include the bribery that Lillian talked about. It has to be in totality. Then we can examine and say, yes, the problem is the law. The problem is the investigation. The problem is the judiciary. Then we can rationally say, this is what we should do.
Professor Latigo, I think we need to just make this very clear and come out very clearly to the public. We talk about bail, and you're disappointed that we're actually discussing bail. But yes, it has covered our space for conversation, and that's where we are. But the issue here is we're talking about bail, in bail. But what is this thing to the common person? Lillian has just clarified here to say, we're not saying we do away with bail, but it shouldn't be easily accessed by a one Professor Gyagenda Semakula, a one Gyagenda Semakula. What needs to be done in this case? We're looking at, and of course all these things keep compounding. We need to talk about our investigations machinery. We need to talk about the quality of our investigators. We need to talk about human resource. We need to talk about the number of, we have so much a case backlog and all these things. We just need to understand this thing, Professor Latigo. You were in that house, you legislated, you made laws for us, you created policies for this country. Yeah. Why do you think we shouldn't be talking about this thing? And how should we talk about it in a way that is not very controversial?
Really, you see, for any issue, there will be a genesis. And this is where my disappointment is. Because what is the genesis of this talk about bail now? I brought this, my statement of, in reply to the President's State of the Nation address of 2009. And the issue of bail
features in there.
It is here. And that time, what had happened? We had people like Reagan Okumu, Nyeku Chula, they got arrested. It was politics. And the personal discontent of the president, but the victim was the courts. Because when you say that you need to amend the provisions on bail, you're actually condemning courts that are not exercising their responsibility correctly. And who is the appointing authority in this country of all those judges, if not President Museveni? And there have been cases where people have complained about appointments, but he's gone ahead and executed them. And we still want, like we say in Acholi, to talk with the grass in our mouth and discuss bail. For what?
Wait, sir. Come to the conversation. We talked about bail.
You'll excuse me, the advantages that they are all. First and foremost, it is laughable and absurd at the same time that indeed we are discussing about bail, because there is nobody complaining about bail apart from General Yoweri Kaguta Museveni.
Isn't that good reason for us to talk about it?
And I want to tell you two things. One, when you look at this discussion, you look at it in three ways: the legal way, the economic way, and the political way. And I will tell you the legal way. Our constitution, first of all, I have not had the opportunity to look at the cabinet paper because it has not also been yet brought to Parliament, but I know that it has been passed, that they want certain amendments. And I have been privy to the documents in the media, looking at the specifics of what they are saying. They are looking at Article 23, which talks about bond at the police. They want to extend it to 48 working hours. Now, I think that will imply from 8 to 5 to make it the 48 hours, because now it was 48 hours. And the practice even has been that the weekends have not always been counted anyway. And then they are looking at the bail application to go 180 days. That is, I think, close to 6 months. Now, it is very absurd because, as our sister here has said, Article 28 and the Rome Statute and the common law that we all are accustomed to, being former British protectorate, clearly states that one is presumed innocent until proven guilty. That is a whole article in the Constitution that must be first amended before you talk about what you're talking about in the bail reforms. That is number one. Number two, Article 92 of the Constitution stops Parliament from enacting any law of which a decision has been reached upon by court. And this was discussed and espoused very clearly by the Chief Justice, Justice Batka Turebe, Justice Apio Aweri, and many other Justice Faith Monda, who are even living up today. And they settled that matter in the case of, I think, the Human Rights Foundation versus the Attorney General at the Supreme Court. And in that matter, it was clearly discussed and a judgment reached in favor that bail, it was discussed that the matter of bail was discussed that if you, Article 92 and the Constitution and the Supreme Court ruling judgment is to the effect that you cannot revisit a matter that has been decided by court. Now, if it is brought back to Parliament, that will be an abuse of the doctrine of separation of powers. The independence of the judiciary shall be attacked. And I also want to tell you, the President, General Museveni, is not discussing what they are going to use the 48 hours, business hours, and the 180 days. The question would be, how do you solve the entire criminal justice problem in Uganda? Is not by usurping the powers of the judges and their discretion, because after all, the judge is going to be the final person to determine the fate of the suspect, and this person is a suspect. I want to tell you, Mr. Gyagenda, that when you discuss the bail application that it is very easy to get, it is a lie. Bail is not easy to get. And what is the purpose of bail? The purpose of bail is that, one, the evidence and the investigations are not yet complete. And this person is presumed innocent until proven guilty. The question we should be talking about here is the issue of, one, how we get a speedy trial. Increase the budget of the judiciary. They sought the other time for 600 billion, they were only given 200 billion. You have 126 magistrates managing over 300 administrative courts. You have 55 now chief magistrates. You have, that is now a backlog of over 10,000 cases. You have 15 judges at the Supreme Court. You have only 11 judges at the Constitutional Court. Now, if these people do not have a budget, there will definitely be a backlog and lack of effective trial. These very judges you have are the ones who handle criminal, are the ones who handle commercial, are the ones who handle civil, because you are lacking to have enough human legal resource to handle these matters.
And maybe just because of that, before you deviate from that, because it's just good to give us the numbers and to share these numbers. What is easier in this case? Is it to produce more judges, more magistrates, more justices, or doing amendments tailored to manage a situation? You just talked about bail application, and you know that bail application in this country is not participatory. When I am applying for bail, the victims are not inclusive, they are not included in this, and these are some of the recommendations that
it is a lie.
No.
Gyagenda.
Victims are only witnesses.
Gyagenda.
Criminal law is committed against the state.
Exactly.
And the state.
So do you want them to participate?
Why they call it an application, and where our arguments are, that why it is an application, the judge has the discretion to handle that entire case. It is in a professional judgment that the judge will determine that this individual is going to influence, if I release him now, he is going to influence the matter when he is out.
More importantly, when you are applying for bail, you must justify why you should be granted bail.
Exactly.
Yes, and let me tell you, Genome 7 should know that bail is easy for the rich and those that have status. Bail is never easy for the layperson, because the process of just starting bail, my brother, let me tell you, we are following a jurisprudence. Wait, we are following a jurisprudence.
With the issue of the bail, then if it's discriminatory, maybe probably that's also the reason
no,
why.
there are reforms that should be debated on bail.
There are reforms
but
that
it's
should
not
be
the political issue.
But it should not be the political issue.
That NRM is advancing.
And I want also to tell you, that the problem that will solve these murders, the capital offenses that we are talking about, is an effective judiciary, number one. Number two is an effective investigative department of the police. Many of these criminal cases have been dismissed on technicalities. And let me tell you, once a case has been poorly investigated and it is in capital nature, for example, the forensics department. These days, world all over, from 1987, countries in investigation have improved that in such matters, even the DNA determines. We are not yet there. How many laboratories do we have? Where are we focusing our resources in handling these crimes? Now, if you answer those questions and understand the law, you will find a better solution. If you do not clean up the police, look at the 17-day report. How much has it been affected in making police a better institution? Genome 7 promised us that it was only going to get better when he militarizes it. He brought General Katumba Wamala, General Okech, General Sabiti, General Kale Kaihura. We still have the same stories of Kawukumi in investigation. Now, there is no way the president will come here and tell the country that there is a problem, people are getting bail. And look at the people who have suffered in prisons when they have been wrongly charged. you are aware of a person in Entebbe who was wrongly charged, denied bail, spent over 8 years in prison, and later he was released. In Ugandan laws, compensation is like sending somebody to another hell. What do you make of that?
Why wouldn't that be a rider on bail now? I'm only thinking, why wouldn't it be a rider? That if you are incarcerated there, you denied bail, like you want to presume, and later you are discovered to be innocent, why wouldn't you have that rider of compensation as opposed to maybe disproving the other?
You can never compensate. You can. I told you that this is also economics. Let me tell you before you even talk about compensation. Because the president, the way he's speaking, talking about the 180 days and the 48 business hours, he's increasing the budget of looking after inmates. You need a new uniform, you need posho, you need bins, you need medical, you need personnel. Look at this now. You are a poor country that has a lot of challenges to handle. There is no alarm whatsoever why you would even need to ignite a debate on that, unless your political interests of arresting people like Honorable Sejirinya, Honorable Sawanyana, then Reverend Father Bishop Mugisha. It begins to cast the doubt why you are taking a country into a very expensive process of amending the constitution for your personal dynastic interests.
Lillian, come to the conversation again.
Well, for me, I think when we're discussing this issues of bail, let's not narrow it to the level of a political eye only. Let's put into consideration or get into the shoes of this vulnerable person who has been a victim. And I get surprised when members here are trying to hide from the fact that the courts of law has not been a place where people cry when they go to. I think we need to be honest enough that people have been going through hell. You see someone and you know there is evidence. Of course, with issues of the law and court, you can only prove the evidence in courts of law. Even if I know that X is responsible for defiling my daughter, but if X can afford to buy his way or our way out, we'll go hands-free. So what are we going to do for this vulnerable person? That we need to be very sober when we're discussing these issues. And we need to be as practical as possible. I do agree with him when he talks about there are challenges, and you must agree that there are challenges. That is where the highest level of corruption is. And you shouldn't sit here and pretend. There are empirical evidence on ground. Somebody can maneuver around before you know it, is out. Who can afford to release money from the police, there is money, state attorney, and then the magistrate. All of a sudden, these things are happening under the sun. Let's keep the political eye first aside and look at the practical perspective. It would be very disheartening. You see, for a president of a country, and probably the executive, when there is a constant challenge, you will definitely look for solutions that can help in addressing some of these issues. And what I would encourage, a discussion that I would encourage, is that when we look at the police, what should we do to support the police? We need to support the police to the fact that when someone is going to be arrested, there has been a thorough investigation. They don't just rush into arresting someone. This is where I personally would make a key point there, that we have to empower the police. When they are going out to arrest Lillian Abe, and it's on a case of murder or in a case of defilement or rape, there must be a thorough investigation done. I think this is what we need to look at. I don't want to attach emotions, look at the international wings. Yes, I do appreciate the international engagements, but also as a country, this is our house. How are we going to address some of these challenges? And how are we going to tackle and touch? You know, something new coming up is always very difficult, and people tend to, you know, find ways here and there. But the fact is the rate of criminal offenses in this country is beyond, it's not manageable. Okay. We need to empower the judiciary, we need to empower the police, we need to address these issues if we are to be secure.
Okay.
Because I don't want to be in a situation where I can just craft something and then I know I can buy my way out, and somebody marches on the streets hands free. What are we supposed to do on handling such a thing if it's not by law?
Thank you, Lillian. Professor, before I come to Sarah here, my brother Mufumiro here brought out something very important, and this is the presumption of innocence, as our laws actually are. But should we think that the presumption of innocence negates public interest or the victim's interest at that? For example, we know that when you commit a criminal offense in this country, you're committing it too at the state. A review recommendation report that was done by the Uganda Law Society in August 2019 captures and looks at all the things and says the public looks at a bail to tantamount to acquittal in a way, because it is the right for me to apply and it is to the discretion of the judge to actually grant me this thing. But does this also consider the bail guidelines that we have in this country are also very specific and significant on how to manage and of course how to cater for these other interests of the victims and all things? If we also just adamantly say that yes, we know that criminal cases are against the state, and if I do anything to her, then she has to bow out, let me deal with the state, be a witness. Yeah. And when we talk about, now that's when I think the hearing is on. I think Professor Latigo, could you please just come into this as we talk about negotiate the presumption of innocence, which is of course in our laws.
You know, when you put an argument against public perception and you are dealing with a perception or supposed perception which is not derived through a very systematic. I'm a scientist. If I want to get public perception, I will do a survey. And I'll even structure my survey in such a way that I will stratify and say if I ask the categories of the SARAs, their responses, I will have to understand the context. If I ask my uncle in the village who never went to school, I will have to understand their context. Now, when you say public perception, and you don't have a single systematic study that brings out the public perception, and you justify what you want to do, for heaven's sake, we are dealing with a country. We are dealing with institutions. And therefore, let us operate not like those hunter-gatherers that we used to be.
To maybe just highlight on that, the public perception that you're possibly talking about here, like I told you, it's captured in the recommendations of the Uganda Law Reform Commission of 2019. They discuss that. They talk about that.
Are they saying the bail should be limited further?
No, but of course it comes to the perceptions of the public.
No,
they didn't bench, they didn't really zero onto them, but they consider them, they look at them.
My brother, you know, my sister Lillian, we come from Acholi. And I can give you a very simple example that operates even now, even when there are clear laws on murder, etc. In Acholi, somebody will kill your brother or nephew. You have a right, culturally, a right of revenge outside the law. But at the same time, once the elders have come in, you don't have a right to do anything. And I can bring you many cases where actual murders have been committed and the matter has been settled culturally and nobody was taken to court. They will say, if the state wants to prosecute, for us, we no longer have a problem. That is more than public perception. That is practice. Now, unfortunately, we should not run away from the context of this issue of bail. The president became very loud on it when the two MPs were granted bail. And I would do, if I were a judge, I would definitely grant bail to members of parliament, because as elected representatives, you are probably dealing with them not as individuals only, but as a relationship between institutions and the image of those institutions. And unless there's really a very strong evidence, by the way, this issue of bail will not arise if all the evidence was there and the trial was proceeding. The severity of the offense and the nature of the offender will make the judge say, you cannot get bail. But this is not what is happening. So, it is painful, but it is painful.
It is hard for you.
And there's something that I want to say. You know, I don't know how many people are taking interest in what is happening in the United States, where there are strong institutions, clear laws, but bad leadership of one man, Donald Trump, has soiled the American state in a way that I don't know how they will recover. The anger that you find, even what do you call it? This particular thing is called what? You know, hatred of human beings. The conflict between whites and African Americans now, you know, and it did not arise because there was a lacuna in law. It arose because the president, who had the mandate to preside over the state in a very judicious and objective manner, became, you know, biased in the decisions. And I like what congressmen who are investigating this invasion of the Capitol. Congressman Liz Cheney, a Republican. When she said that Bannon is refusing to testify, but for her there's something more to it, that it is evidence that Bannon and Trump had a vested interest in that invasion. And when I hear Lillian trying to justify the bail thing based on things which are not true, then I will say this is very sad for our country, because I expected that the parliamentarians will go there and debate objectively.
Are there evidence? What I'm saying has got evidence. I can mention names and cases which has been cited on just a recent past.
I can say that let them, those who think supporting the president is the right thing, let them go in that parliament and make the constitutional amendments, and they will come and ask some of us.
Okay. Well, son, I'm coming to you, to our viewers, those who are following the conversation. Please join us. The hashtag is UBC behind the headlines. Our Twitter handle is, of course, on. You can also send us messages on 0709-602-592. The number to send your message is 0709-602592. That's the number for which you can send your comment, your comment, your question, or anything, opinion onto what is happening. Remember, looking at justice in the face of the proposed bill and reforms here. Mufumbire talked about something which you'll come back to later, of the period. We talk about the 180 days. We talk about maybe this other 40. Yes, but the 180. We also need to a probe into our Trial Indictment Act norm. What is it supposed to be, or how has it been? We talk about something that we do not have, or something that we've been discussing. But Sarah, here is where we are. And of course the discussion gets cozy all the time. If we got General Yoweri Kaguta Museveni out of this conversation, would we still be proponents or opponents of anything concerning bail?
Well, I think Dr. Lillian will answer that best. Me as a constitutional watchdog, my eyes are on the Constitution and the other laws that affect the laws of Uganda. But when you go to the Trial and Indictments Act, Section 15, it talks about exceptional circumstances under which courts should grant bail. So when you hear the debate on bail, to know that it's just political, let's look at when this debate, because this is not the first time we are having this debate, except that for the first time we see a speedy movement of a cabinet paper, and maybe next week or so, NRM caucus, and then Parliament. But before, the controversy started in 2005. Of course, that was obviously after the rearrest of Besigye and other reform agenda supporters then. And then we saw in 2011 walk to work. Even some people were denied bail over the same controversy. From 2005 to 2007, 9. In 2007, unfortunately, the same reform agenda supporters were rearrested at court again.
2007?
Yes, the one that included the
that was FDC now.
Yes, yes,
that
yeah.
was FDC now.
FDC, yes, FDC.
Because
yes, which included
we walked out of Parliament.
Yes,
actually.
yes, I remember that.
And,
we had gone
yeah.
back to multi-parties now. It was FDC.
It was FDC.
So Besigye's brother was among the people rearrested then, and then went and charged Sasi. Went and was charged in Bushenyi for a murder of a non-existent person, and he died in prison.
He died, yeah.
John Byarugaba, the so-called John Byarugaba from Chamhunga, killed in Maramagambo forest, never existed. After 4 years, DPP lost interest in the case. People were given bail, rearrested. Some of them lost their lives in prison. We saw the most recent, the Besigye treason case. After so many years, 2016, 2020, 2021, DPP lost interest. If Besigye had stayed in prison.
But it's mandatory bail.
No, wait. If and this is the bail that they are trying to take away. They are attempting to scrap. So imagine if Besigye, from 2016 May, had stayed in court for a non-existent case for 5 years. Later, no trial, no investigation. The aim was just to arrest. So we have a criminal justice system that is abused. People are first arrested, then think of a charge, then think of investigating, then the prosecution later, or at most times, for political actors, they fail. There is never any prosecution. So you look at that fraudulent system and abuse of criminal justice to attain political ends. And the time which this debate resurrects in the country is purely political. Let me give you a clear example. We have a crisis of defilement. We have a crisis of teenage pregnancies because of lockdown. Just recently, my district, which has less numbers, Bushenyi counted 2,800.
Less numbers of what?
Yes, of defiled girls in this lockdown. Rango region has 24,000 teenage mothers, teenage pregnancies. If these politicians were genuinely discussing about society, the crisis today in this country, in terms of criminal justice system, is the defilement. But did this spark any anger? The president said it's okay for girls to give birth. After all, they are not dead. Yet defilement is a capital offense.
But this is one
No,
of
no,
the
wait.
issues.
Lillian, you will have your time.
This is one of the
You will have your
issues.
time.
To address it.
No, you will have your time.
You
And
can't have
you
an
be organized.
amendment
You
done
respond.
on one.
You will have your
factor.
time.
You will respond, Lillian.
So we have teenage crisis. The president addresses the nation, says it's okay for babies to give birth so long as they are not dead. If the president was addressing the nation and saying, look, men have raped girls, have raped babies, I want to arrest them, you would think that there is a society concern, because indeed there should be society outcry. But the issue comes at the time when opposition MPs are in custody, are given bail, and are rearrested. So what do you want people to believe? And when you go to address the nation, you are not even tackling defilement, teenage mothers and closed schools. You are tackling politics and political persecution. So for us, what we are saying is, of course, it is very bad, and people, I wish Parliament could debate teenage mothers and people who have defiled all these children of Uganda and what should be done. Then you would think that it is a society, it is a people concern. But what they are debating is sparked by two opposition elements in custody who have been given bail, rearrested, and now judges are even fearing to hear those. Yet they have security of tenure, but they are fearing to hear those bail cases. I know there's an application tomorrow, but two judges have refused to hear that bail application of the MPs. But what are the proposals? He did talk about some of the proposals, but they are not clearly addressed. If you look at the proposals Cabinet is fronting, one is that 6 months when you are tried of, and the crimes they highlight.
What is it before the proposal?
Murder, rape, robbery, treason. Those are the highlights of the cases, the charges they are targeting. 6 months without bail.
What is it before? Before the proposals?
Not before the proposals. For any crime in Uganda, you can apply for bail.
No, but I mean, before?
Even after arrest, once you're charged and you have taken plea, you can apply for bail, and it's up to court.
So if you say it's for, let me just ask.
No, you will come in, please. Don't interrupt.
I just want clarity.
I don't think we have reached the session of questions. That's after.
Sir, actually, the questions are in here. My producer is telling me the questions have come in.
Okay, just a minute, let me finish. Because the public has not heard properly the proposals. So that's one of the proposals. The second proposal, and on this 180 days, the Cabinet is proposing that you can either wait for 6 months, or when the trial has commenced, you ask for bail, or when the DPP discontinues proceedings. This is intentionally misleading because this is void. Once the DPP has discontinued proceedings, there
because
is
he
no
has that
case.
discretion.
The case is closed.
He has that
the case is closed, so you can't say you will apply for bail. Once DPP has discontinued the case, this is void. This is fraudulent.
But that's already catered for in Article 120
No,
of the
but it's a
Constitution.
proposal by Cabinet.
Okay.
Yes, among the bail reforms. It's a proposal. Void, fraudulent. It does not exist.
For the discontinuation,
what she's saying.
Mufumbira, will come. Questions are here for us. We need to
Once a DPP has discontinued proceedings,
then the case has
there is
gone.
no case.
The case has gone.
And the Cabinet is saying apply for bail after DPP has
supposed to be
So
home.
in which case?
Okay, let's listen to or get comments and concerns here from the public. I need to see some of these on screen. I am challenged a little because in too much light I do not have the capacity to read very well. This is Wangola, I think, Francis, tuning in from Manafa district. Good evening, Mr. Gyagenda, and to all our panelists. In the spirit of constitutionalism, applying for bail should remain a right, but granting it should be at the discretion of the judicial officers handling it judiciously.
That's
but I think yes.
law.
Okay, that's the law. This is Tony that's Katahia from Kahaya from Namugongo. If I may ask, is bail the issue that is affecting Ugandans? Now, that's one question.
Christians.
Okay. There are a lot of Ugandans who want it to uplift their well-being than bail. So let the government deliver let the government deliver what Ugandans want to uplift their well-being and the judiciary carry out its duties. Thank you so much, Kahaya from Namgongo, and this is Ezra Nkirirehi, I think. Well, good panel, the issue to address is not bail or no bail, but to have timely investigations before the arrest is such that once arrested, trial begins immediately and not to store people in jails on remand. Yes, I think that's very important, and of course that's one of the issues that I want to also get into. This is Omjugu Moses, commissioned cadre of the revolution. The issue of bail is a far-fetched idea, and it should be thrown into the basket very far, like China. That's what they say. The status quo should remain. Okay, the status quo should remain, meaning let's not deal with all the other things. Okay, thank you so much. This is Nebat from Masaka, and he says the problem is that some politicians don't want the common person don't know what the common person is passing through. Whenever he sees a criminal out of prison just a day after his arrest, it's only when they defile a daughter that they can understand what the president is talking about. Thank you. Well, thank you so much. Who is the other one? Council Paul. Yes, says good evening, Mr. Gyagenda, and thank you so much. Thank you so much. For me, the Honorable Gengala Tigo, Honorable Sarah Virete, and the second honorable gentleman for the mature and professional discussion about the application and the grant of bail that is due with due respect to humanity. Thank you very much. Who is this? I am Mugume in Makiso. Thank you so much for the program. I think the issue of bail should be left with the judicial officers to exercise the powers. The parliament should not mess up with the country by scrapping off the application for bail, right, and end up contravening the international treaties which Uganda ratified. One more, and we'll take a break. Okay, this is Josephine from Gulu. The court knows which case to give or not to give bail. Cases of aggravated defilement, murders, etc. have not been given such. But there are cases that totally have no evidence. Why keep such a person in prison? Let's stop interfering with the judiciary, but only support them to handle the cases first. Well, those and many more others, follow us on Twitter, YouTube, Facebook, and continue sending messages. And our hashtag is UBC Behind the Headlines. We'll continue the conversation. My name is Gyagenda Semakula Ziksoka. In studios tonight is Professor Ogengala Tigo, a former leader of opposition, and of course the first leader of opposition. Under the 1995 question, of course I'm going to say.
Because there was Bateringaya and Elijah team before me.
Some organizers were here. Of course, I'm very mindful about that, but thank you so much. Leader Bell is a member of parliament representing Kitgum district. Mr. Waisom Fumiro here. He's the head of trading patriotism and the deputy spokesperson of the National Unity Platform Party. And Sarah Birete, our usual panelist here, the executive director at the Center for Constitutional Governance. We'll take a break and continue. Come back with the conversation for another hour. Stay tuned.
Grow together with one of Uganda's largest companies. Apply for MTN shares for as low as 100,000 Uganda shillings. And when you apply using MTN Mobile Money, you get 10 free extra shares for every 100 shares you apply for. Dial *165*65# or use the MyMTN app to apply now. The terms and conditions of the offer and other important information are set out in the prospectus. For assistance, visit any MTN service center or Stanbic Bank branch countrywide or a licensed broker.
vaccinated today so we can get closer to the normal way of life. Echa COVID-19 chija kugwa.
You know, you could just buy a new smartphone from anywhere in Uganda. Dial *175 *94# to activate their 100% double data bonus offer on weekly or monthly bundles for 3 months. Better yet, you automatically receive free 1 GB valid for 30 days. You are hooked already, aren't you? Enjoy 100% double data bonus from Airtel. Buy a smartphone from anywhere in Uganda and insert an Airtel SIM card. Dial *175 *94# to activate a 100% data bonus offer on weekly or monthly bundles, valid for 3 months. Dial *175# and select your preferred bundle to activate a 100% data bonus offer on weekly or monthly bundles, valid for 3 months. Airtel, the smartphone network.
Getting GoTV was the best decision James has ever made. Finding a good place to watch football was never easy, but it was costly until James discovered something big. Now he can finally enjoy the benefits of homegrown advantage with a decoder and 1 month of GoTV value. For just 25,000 shillings, enjoy the world's biggest leagues and cap competitions. GoTV Uganda, love it.
Uganda, today is a great day to work towards your dreams. Dial *185 *7# and select savings to save as low as 500 Ugandan shillings on regular savings or 250,000 Ugandan shillings for fixed deposits. Airtel Money Super Saver is powered by KCB Bank Uganda. Airtel Money, instant, secure, borderless. T's and C's apply.
Well, thank you so much and welcome back from that short break. My name is Gyagenda Semakula. This is Zeko Soka sitting in here for Charles Odongtho on Behind the Headlines tonight on UBC TV. Now you can follow our conversation. We're live on Twitter. We are live on our YouTube channel, which is UBC Television Uganda. You can also just get there, follow the conversation. And of course, you can also send us messages via text or WhatsApp on 0709 602 592. To be part of the conversation, we talk about justice in the face of the proposed bail reforms. And with me in studios is Professor Ogenga Latigo, a former member of parliament and also leader of opposition. He's with us. Lillian Abel is the member of parliament representing Kumi district. Kitgum District, I beg your pardon. Thank you so much. Kitgum District. And with me in studios is Alex Boyisam Fumbiro, the head of trading and patriotism, and also deputy spokesperson of the National Unity Platform Party, and Sarah Birete, the executive director at the Center for Constitutional Governance. You had made that submission. Let me come to you, Mufumbiro. You had something to say as you also get to interact with the public. But I think it's also just civil. That I know it's banter here and there. Write down a comment or a concern that you want to rebut from a colleague to be able to just make the debate run smoothly. Mufumiro.
I think she brought back my mind, and it is very interesting that Abba and Professor...
She's not
Lillian
Abba.
Abel, she's a former person of FDC, most obliged, and the senior leader. I remembered the case of Dr. Kizza Besigye towards nomination, and there was a very big argument in 2005, where I think the then Attorney General, Professor Chidu Makuya, one of the most brilliant individuals at law, tried to suggest that the doctrine of innocence, the normal doctrine that one is innocent until proven guilty, would be changed, therefore defeating the nomination of Dr. Kizza Besigye. This was loudly rejected by all the legal brains of this country and internationally. So this discussion to us...
Actually, to you complete that, we have to give credit to the now Clerk to Parliament, Adolf Mwesigye. He was Deputy Attorney General. He's the one who gave the contrary, actually refuted the view of his Attorney General, and we went ahead to nominate Dr. Besigye.
Yes. So these questions have always come up at such political times. And that is what makes them political, because there are murders that have happened and the head of state has accepted and he knows the culprits because they are simply under his armpits. And I will give you the examples. The murder of Zebra was a cold blood murder. If you are telling the country that you want to solve crime, then it would have been very important today to see the prosecution of those individuals. I want to remind you of the murder of Yasin Kauma in Arua. When they murdered Yasin Kauma, General Yoweri Kaguta Museveni wrote a missive saying Yasin Kauma had been a proven terrorist, not even a suspect, and therefore he had been taken out. A few days later, the same general who had condemned one person of being a terrorist sent money, 20 million shillings, through the presidential advisor on funeral rights, Catherine Kusasira.
No,
then
that's not there.
It was there then.
No, there's no presidential advisor on funeral rights.
They said this was the presidential advisor on Mabugo. Then these are facts.
No, but of course, maybe you say not.
She
the
delivered 20 million anyway. She delivered 20 million to the family of Yasin Kauma. Now, this was a manifestation that that person had been actually wrongly killed. I want to remind you of a very interesting case. They come from Acholi land. We have the case of Kanyamunyu. Kanyamunyu. Yes. The victims from Acholi land came in. It was a very, very interesting case. This gentleman had an unlicensed gun. A gun that nobody knew where he had picked it from. That is also an offense, a capital offense of its own merit. He picked his gun and shot this young man who had gone to an ATM to pick money to enjoy his night. After shooting this young man, they run around, make sure that they run around so many hospitals such that he is no longer conscious to tell the story, and they drop him at Novik. He gives a dying declaration. That is very important at criminal law. And the persons who are there could easily understand the language that he was speaking, because I think he was speaking Acholi. What is very tear-dropping about that case is that the president got involved at two stages. One, getting bail for Kanyamunyu to go and fix an arrangement he himself had organized at the family of the elders of the Acholi land to exonerate Kanyamunyu. Kanyamunyu, after wasting court's time, gets bail after 3 times failing to get bail. Now I'm telling you, this is orchestrated in State House. Somebody who is now telling you that bail is something that we need very badly.
And just because of
Alice
that...
Kaboyo, listen, because you must look at the honesty of the person who is speaking about this. Today, Kanyamunyu was given 5 years, but the influence was the state. 5 years.
Mufumbiro, isn't it a good case? Isn't the Kanyamunyu a good case? It talk about bail. But because when Kanyamunyu was granted bail, it took us in uproar, the public, and said, why and how could it be? Wouldn't that be a very good case for us to actually say?
The reason why the public went into uproar, and the reasons we are giving you, that the president he takes advantage of the system and then uses the advantage that he has taken into taking the society to be gullible.
Doesn't he deserve the support now that is actually...
He cannot deserve the support because
he's now deviating from the area position, now to say we need to...
My brother, the jurisdiction, the professional touch of the judges, 2 judges, by the way, 2 trials, 2 times, The professional, the jurisdiction, the power of the judges to grant bail was that he cannot get bail because even the gun had been disappeared by people who are powerful to the state, people like Andrew Mwenda. When you see Andrew Mwenda, you have seen the SFC. Now, when such things happen and the state and the office of Genome 7 uses advantage, Alice Kaboyo,
if he's actually saying, if he's now saying, let's not make bail easily accessible to the Kanyamunis of this
but
world.
he's the problem. He's the one who.
Why wouldn't we support his position now?
He is.
I'm asking you.
He is the one who abrogates the constitution. No, I am telling you that he only takes it to his advantage. What you're promoting is impunity. The only reason they are talking about bail and murder in particular is because they want to have many of us political actors who are speaking the truth to the junta. Many of us, they want to take us away for long days, for many days, such that the government can continue to act the way it is acting without anybody telling them back to whatever they're doing to this community.
Sarah, you just had something to comment on here before I get to Lillian?
Yes, briefly, you know, we need to see if we are saying bail for capital offenses. Because in law, again, it will be difficult, the principle of equality under the law. You are saying murder, and defilement is not listed in the cabinet report. It comes under ETC. They are targeting murder, treason, robbery. That's the main focus. Why it's number one on murder is because of the current political situation, opposition MPs. Before, the president was talking of bail for the corrupt. I'm sure you remember that. I don't want the corrupt to release on bail. But now it has changed. And when we have regime people, there is a time 3 or 4 ministers were in court, in the anti-corruption court. Bail was never controversial. Even the provision under the Magistrates, MCA Magistrates Courts Act, that would provide for lapse of bail when you are committed, was removed in favor of Kutesa.
And Nasasira?
In a few days, because Kutesa and the colleagues wanted to benefit from that. The Constitutional Court in a speedy manner outrode that provision. So we have this kind of legislation according to the moment. I think people need to know that the Constitution should not be tinkered with just because of political moments.
And to just give you the information, in that case, it was very interesting because they first committed Professor Gilbert Baliba Sekabu Kenya. The matter was Chogam. Now these three, John Nasasira, Sam Kutesa, and Mwesigwa Rukutana, what was Mwesigwa Rukutana? They sat with actually a certain member. There were three. It was Mwesigwa Rukutana. For them, they sat to the advantage of the system and got bail after she had just said, because there was that after you are being committed to the High Court, then the bail that you attained at the Magistrates Court will elapse. What these people did, the three after Gilbert Kenya had been sent, to show you the inequality, that the bad heart and the dishonesty, these powerful people of government threw that away. And the most interesting newscast, to sum it up, was when they were asking Honorable Sam Kutesa Nasasira to be led to the court cells. It was a hassle. So these people should talk about jail, knowing how much difficult they find it when it is their time to be there. Because that time, always, Honorable, that time will always be there. When if it is not you, it is your relative.
Professor Latigo, isn't the current legal regime what is causing us problems that we need to alter it, do a few changes and amendments here, because it is what we are castigating. What we're talking about is what we've lived with, and all the loopholes, the lacunas that we are discussing are in the prevailing, or the laws that already are here. Don't we need to readjust them to make sure that we cater for what Mufabiri is saying, what Sarah is saying, and what all the other people are saying out there?
You know, honestly, the problem is not the law. The problem is how we look at our roles in this country. The president was talking to teachers, and he told them, I'm the president of Uganda, and if you want, you can find out. This is the same thing. And that is why, personally, the other day when members were, parliamentarians were saying we are preparing this, I cautioned them. I said, don't politicize it. Let these people come with whatever evidence or data they have, like the one Lillian is talking about. Let them present it before Parliament, and we, the country, will be seeing, watching. And we will be, in today's Observer, Professor Jamil, a Ugandan professor in South Africa, spelled out each item of what is proposed. As a professor of law in a country where the judicial system is respected, and whether even if you were a former president and you think you are bigger than the law, you would pay for it like Nzuma did. He spelled it out very clearly. And the problem here is not the law. The problem here is President Museveni thinking that this is his household and he can make any decision he wants. It is wrong. It is as simple as that. If the judiciary say the provisions in our constitution and in our laws is hampering our operations, they are now asking you to make amendments. But if they are telling you we don't have a problem, and you are the one, you are not even a lawyer, you are the one telling them.
That is a problem with them.
The only reason why you are telling them is because you are the president. And the only reason why you get support is because members think when the president has said, he must be supported.
But also,
if the NRM members want to help President Museveni, because there are now no people to help him, the people who will tell him the truth, he has moved them aside. If these young new members think that is the right path, they will be the worst victim of this mischief.
Okay, Lillian, Professor Gangalatigu just said here, the problem is actually not the law. The problem is President Museveni, who thinks, in the words of Professor Latigo, this is his household. Is this President Museveni's household?
And he's not a lawyer.
And
he's not a lawyer.
He was in law school for one day.
Must do you think all members of parliament who sit to discuss law are lawyers? Must you be a lawyer?
No.
To discuss or come up with some of these issues?
I think you must be a lawyer to give
I think it goes beyond that.
Give professional advice on that.
I do accommodate, and we are still in the process of discussing the issue of this bill. And all opinions are really valuable. In a civilized society, we discuss some of the things.
Do we have a problem with the law, or the law is not a problem? The problem is President Museveni, who thinks this is his household.
A doctrine or a set of principles which were set by human beings to govern a society. If it's not working, there's a section called an amendment, and that is simply what is being done. And when these things are being done, you don't expect everybody to support. There are even members within the NRM who have put their feet down and said no. And this is not opposition discussion.
No,
or
was
NRM
the two-term limit
discussion
not working?
So
when it got amended.
Senior, I gave you time. So
let your daughter say something.
Let me respond to this. So we just have to be sober about this whole discussion. We need to discuss. We are going to bring this in the floor of parliament. We are going to have an input. There are some points which are being raised here which are very fundamental, and as a legislator I'm taking key notes about it. But what still remains constant, my brothers and sisters, is that there is a challenge, there's a problem in the society that must be addressed. This is just one of the suggestions to address it. There are other angles that needs to be addressed. For example, our community are very ignorant about the law and the issue of the bail. Do you know that some people think when somebody is released on bail, maybe they've already granted them, freedom. Our local people are like that. We have had a case in Mbarara where 2 people were murdered in their gardens because of a suspected case of having killed a border man. And because the community thought maybe they have been proven innocent, so they took the law into their hands. Such an amendment. Now legislate for ignorance? I thought the other time you were a teacher teaching civility and listening to each other. So I think you listen. So this person, these 2 people were killed. They might be innocent or they may be guilty, but their life matter to the Ugandans. The issue of strengthening institutions cannot go unmentioned. We must strengthen the police to do their work. We must support the judiciary to do their work. But if you say this specific amendment is coming just because opposition members of parliament were arrested, I think this is quite pedestrian to think that way. If it's about them, then they will not be in jail now. I mean, we need to be very open and we need to be realistic. You see, I do accept and support
because it's about
the antagonist.
Wait, sir. Hold it.
My young brother here has to really learn debating principles. So, for me, I don't want to narrow. All the suspicions might be true. Oh, you'll fall a victim. Time will come. A, B, C, D. Some of these things, yeah, well, anybody is not above the law. That's why when my senior here was telling me that members of parliament should, I mean, if you are a member of parliament, it does not mean you are above the law. You must do everything within the law. There are immunities you can enjoy, but that does not mean that if you go out there and do something wrong, the law will not catch you. So for me, I really think, let's look at some of the issues that we should discuss and have it, part of this. Because when we talk about the 180 days, we should discuss, is it too long? What was there before? Before it was 60 days, then you have a mandatory, grant for bail. So these are the discussions we should have. And for me, I really think these discussions will come to Parliament. Parliamentarians are representatives of the people. So they will do consultations. We are still in consulting time. People will be subjected to give their opinion on the floor of Parliament. Okay. If the majority of the people who represent people who entrusted them with their votes look into the matter and deems fit that doesn't comply, they will not vote for it. Okay. So we shouldn't have a lamentation let
me just run and move ahead of all of you and look at the proposals as failed proposals. Let me look at them like that. What about if they fail? Are they not there? They come, we bat them away, throw them away and say, none of the things should actually go. If we maintained the status quo, if we maintained the bail issues as they are today, are we comfortable with that? Sarah, you talked about the Trial and Indictment Act. Section 14 of that, of course, gives, it grants bail, but Section 15, of course, comes with the rider and gives some exceptions. Yeah. Now, these exceptions are also limited exceptions. We need to look into all these things. What about if we said, okay, what Cabinet is proposing should all fail, or it has failed, or it fails? Are we comfortable with the position where we are? Mufumbiro talked about how expensive it is, and these are some of the recommendations, the issues that the Uganda reform, the Law Reform Commission actually looked into. You look at it as a thing for the rich. You look at it as something that only those that have money can actually achieve it. Do we now need to look into those things? What about if all these issues that they're bringing forth, we decide to fail them? Are we okay and comfortable with the status of bail in this country as it is?
You know, when you look at the status, let's look at the status of detention centers, police, prisons. Of course, anybody in police custody has not been charged in court. And there are people who even spend 2 months in police custody or more without being presented in court. When you go to prisons, more than 50% of people in prison are on remand. That is pre-trial detention. So yes, we have, the way the law as is, the law has no problem. we have a problem with implementation. What is the problem? Poor investigation methods in the country. Of course, the police is less resourced. The police is less facilitated. The ability to detect. First, the police should focus on detecting and preventing crime. But even when crime has been committed,
Orchestrated.
yes, speed the investigation. The 48-hour rule presumed that police would investigate and establish a prima facie case before arrest. So that if you charge somebody, today have arrested Sarah, you should be able to present him even in court tomorrow morning because you have done investigation.
Is that tenable, Sarah?
That's, no, it is.
It presumes, but is it tenable?
No, it is. It is, and it is working in other countries. You should first investigate. You can't even summon people without charging
yes,
them.
it exactly works
for
in
general
countries.
inquiry.
Sarah, I think it works in countries where you first do the investigations.
That's
we
what that's what the framers of our constitution envisaged. First to do investigation before arrest. But in our case, everything is upside down. They even arrest you without knowing a charge a case you've committed. Yet Article 28 is very clear. Tell the person the crime they have committed. Tell their relatives. Even that is abused because the police assumes, arrests, then investigates. That's why they are not able to meet the 48-hour rule. So, but if they were to first investigate, establish some prima facie evidence, and then arrest, then you are able to charge. That does not need any legal amendment. Let's look at the prosecution. Just the other day, yesterday, but one day, we were in Parliament, appealing for proper remuneration. The president of the Prosecutors Association said that they even live in conditions where they expose to criminals that they prosecute. In slums, the areas they eat, their petition is on record in Parliament. Those are the issues we should be focused on if we were a serious country, other than prosecuting a few individuals. You come to courts. The court leadership has been clear that they have no issues with laws the way they are on bail, both the Chief Justice and the Deputy. These are the people, this is the arm of government implementing. And if we have to have respect for the judiciary, then the debate should be, what do we think is the problem? Where do they need support? The Chief Justice has said where they need support. They need proper remuneration. They need the number of judicial officers
should be
increased. He has mentioned number of magistrates, number of judges he needs at High Court, Court of Appeal, and Supreme Court.
Do we have them somewhere?
All these benches are not full. The Chief Justice statement is very detailed.
Yes, the Chief Justice's statement actually solves some of these puzzles in here.
Yes.
But do we have these magistrates and judges somewhere that we're not deploying them? Or
no, they are lacking.
They are lacking.
All of them are deployed, and every level of court is lacking.
Exactly.
So these are the issues that Parliament should be debating, other than politicizing and running after those to curtail people who are on the opposing side of government.
Oh, okay. Does Professor Gyagenda insist that the debating bail term is above this discussion? And the genesis of this was in 1987, the video that we showed the courtesy of Owanapedia. And the judges follow the laws as passed by Parliament and not vice versa. And this is where Professor Gyagenda was. What is he running away from, Professor?
That what?
What are you running away from? Because in Parliament, the judges follow the laws that you pass, not vice versa. And this person was responding to you saying the genesis of what we're talking about here, because you said it's important to get back to the genesis. We presented a video here of 1987 when Mufulira
that was resolved in the Constitution. 1987 is pre the Constitution.
Yes, pre the Constitution, but that time
Seven has been around for 35 years.
But he started talking about he started talking about bail before you were born, I am sure.
Yes, the debate was
before you were here.
By CA.
Professor Latigo, respond.
What? I'm not running away from anything. I'm just saying that Parliament has better things to do, just like somebody did mention. There are many pressing things that need to be sorted out. We cannot waste our time on a thing like this. And like I keep telling people, I'm a scientist. Give me the evidence, not your sentiment. Yeah, I don't care who you are. Your sentiment is not evidence. Put it down clearly that this is this, this is this. Just because it is President Museveni who said it doesn't make it a fact. Let me read here. Let me read. This was our statement in reply on good governance. And I said,
you as leader of opposition?
Yes. And let me read.
In 2009?
Yes.
Okay.
And I said, you see, last year on the political situation, we asserted, and I quote, in spite of the apparent improvements, it is now clear to us that there may have merely been a change in approach to dealing with the opposition by those who now find the civilized suit of multi-party democracy discomforting, and that the basic goal of curtailing freedom for the opposition remains. The key strategy seems to be the instilling of fear in the people and ensuring that the police and other state organs will be able to act violently and resolutely against the opposition whenever directed to do so during the elections. These are still things you find happening even today. So what would you say the problem is, if not the government in power?
This span of experts is neither knowledgeable nor balanced. Apart from Professor Latigo, where are the seasoned legal minds of this city? What happened to Odong Tho? Okay, Odong Tho is sick, and that's why he's actually not with us here. Odong Tho is sick, he's not with us. I said that earlier on. He will be here. I'm only just sitting in for him. It is his program. Another question here says, just a question coming now. These are responses from Twitter. The others are actually responding. The huge problem with the so-called fake Ugandan politicians in the opposition is to try to oppose whatever is from their side, whether good or bad. They see Yoweri Kaguta Museveni and any other people behind him as their enemies. And of course, tagged you, Lillian, and Sarah. I am already impressed tonight by the performance of the deputy spokesperson. You have somebody whom you've impressed here. Okay, then somebody says you could have had it, I think was responding to another. I would either ask or, okay, well, that's a different one, I think, responding to another. Okay. Lots of things coming. I just need to sort them. They will help me sort them here for me. But of course, this is where the debate is. Professor Latigo, just before I went here, and these others also respond to it. Waiswa talked about the Kanyamunyu saga of 2017 October. And a member of parliament who is a lawyer, what's his name, Odonga Uto, Samuel Odonga Uto, and people from the Akena family, of course, moved and yelled, cried in court, and did all the things too. Why? Because the public sees and the public construes, the public looks at bail as tantamount to acquittal. And they were led by a member of parliament. They are a member of parliament to still think the same way. And this was a very good case for us to say that, yes, every one of us said you can't let Kanyamunyu go for all the reasons that Waiso has given here. You are in possession of a firearm, you have it illegally, it's not a registered firearm, you have all the things happening, and you've even killed a person, and you are actually asking for bail. Now, President Museveni, even in his latest submission opinion about this, he says, when we make bail very easy for everybody, this will escalate impunity and recidivism, where one can do it and say, I will go and ask for bail again and do it. Professor Latigo, just from the Kanyamunyu situation, don't you think that, yes, when we discuss bail, it's worth the discussion?
the Kanyamunyu situation, and I'm glad that you brought in my brother Odongauto.
Samuel Odongauto.
Once you politicize the court process, you create a situation where people become sentimental rather than rational. By the way, that Akena who was killed, I knew the family more than Odongauto. But in my position, I have to entrust the judiciary to exercise their responsibility as fairly and as freely as provided. You never saw me once in court. Nobody quoted my views. I had very strong views. And that is how it should be. When the judiciary says, look, we are doing everything above board, respect it. If the judiciary was the one complaining about bail, everybody is going to complain about bail. The person who wants bail is going to complain when not granted. The person who doesn't want the other person bail, granted bail, will complain. No, but complaint is not the issue. The issue is what are the factual things that we are dealing with. And in this regard, what are the factual things about bail in this country that requires us to even tamper with our constitution? Because the constitution, to me, is a very important thing. We don't have to, the answer cannot be every time that we have an idea, we run and amend the constitution. In the end, if people have no regard for the constitution, then the whole body structure, the legal body structure of the state will be sick. And that is where my biggest problem is. And this particular push for bail, the timing is bad.
It's about timing?
No, the timing is bad. Let me explain. Because these two MPs are granted bail legitimately. If there was something like a preliminary trial where evidence have been adduced and there's indication that these guys are, you could almost conclude that they are suspects, strong suspects, and is granted bail, then you say, why? But you have not even presented a single thing to suggest that these people were responsible for what happened in Massacre. As legislators, you know that you have access to them, you grant bail, and you don't even allow them to go home. You grab them from outside the prison gate.
Professor Latigo,
yes.
Was the arrest a refusal of the bail or of different charges, other charges?
No. If you look, if you want a fresh murder charge, the decent thing is to let that bail process play itself out. Let these guys go home, and you come with your warrant of arrest and said, we are arresting you.
Through the speaker.
Yes, the same process. But if you now usurp the powers and you ask, what is really this strong motivation? What more evidence do I need for me even to waste my time to debate the merit of the proposal and the demerits? Why? And you know the dishonesty that was being talked about. I was chairman of actually Technical Working Committee on Oil and Gas. The Foster Wheeler company was contracted to do a refinery study. That refinery study, they had to talk about where the oil that will be refined comes from. The oil fields in Acholi, Aliech, Jobi, Jobi East at that time. The Foster Wheeler study puts the name Elephant, Buffalo, Buffalo East, which are not the names of those oil fields. Is that not dishonesty?
Did you challenge that?
Yeah.
You did?
We did. We didn't challenge. We just said, this is not fair. We wrote a brief to the president. We cannot manage the state like that. Because in the end, when President Museveni leaves, we will face the consequence of the things that he has done. And our country can easily collapse. This is my concern.
Okay. My producer says there are some questions yet to respond to. Just before we close down, we stop at midnight and we have about 15 minutes to end the show tonight. Let me have a few of those comments. This is Meru from Masaka. If the constitution mandate for 180 days, then why should someone be given bail just in 1 week before even the victim's family heal of the wounds? Now, that's a comment coming in from Masaka. Soroti City, Isaac, Israel, says politics should not affect the constitution of Uganda. Political parties come and go, but Uganda will always be present. That's from Soroti City. Now, Lukia from Okono says thank you so much for the fruitful discussion. Number one, what's the input of Uganda courts to the bail issue? And I think that's very important. And none of us, I think, will respond to that. For the courts?
The judges have spoken.
Oh, the judges have
spoken. The leaders of the judiciary have spoken.
The judges have spoken.
Yes.
Then, well,
They want a budget that is appropriate.
They want the budget.
They want an appropriate budget and
human
enough
resource.
judicial officers.
Human resource. Number two, if the police investigations are fast and accurate, then bail issues wouldn't arise.
Obviously.
Yes, we agree. Thank you so much.
Yeah.
Slight, I think from Yumbe here says, thank you so much from Yumbe, bail is abused and must be reformed. Now, that's the coming in. And I think we'll read this finally from Kato Richard, Chairman, NRM Nansana Municipality, just right here. He said, thank you so much for the show. It was Dr. Kiza Bestje's wife, Winnie Byanyima, who pleaded to Kanyamunyu and wanted him out of jail. Not the president, as Mr. Mufumbiro should take note of that.
Actually,
this one is from Nansana.
Actually, the two people from Acholi are here.
Okay.
And you have records. The president.
Yes. We're closing down, and this is your
But did you
final
ever
submission.
see
No,
the wife, Dr. Kiza Bestje, in court?
Lillian,
Who was in court?
let Raisa submit, and because we're closing down, we will come to you. Yes, Mufumbiro.
The president is on record having got statues of money, flew to Akena's ancestral home, met the family members, gave them a lump sum of money, promised them justice, came and organized. Kanyamunyu got bail, went to Acholi, underwent the cultural Matoput
reconciliation.
All these were done by General Museveni.
Is that intended to exonerate Winnie like
no, I am not
municipality
discussing Winnie. I am discussing the authority that is coming to the public to tell you that there is an issue of bail, and yet he himself has been a beneficiary of the same.
Is the bail law in this country?
You get my point. You get my point. I wanted to give you another example.
Listen to this.
I wanted to give you an example.
Is the bail situation in this country as it is today amiable? Is it okay? Should we just maintain it as is?
The laws governing bail are very okay. It is only the need that is desired is one. Look at the investigative department. I have told you that these days, if DNA, they can look at a case. There's a very interesting case I grew up desiring to solve, and that's the case of Dick Katende. Now, all over the world, cases that have happened years ago, they have been advanced technology. There's more
They're getting exonerations, of course,
collection
of DNA.
Now, that is where we should be looking at how we improve the human resource, the intelligence
That's a recommendation into the current situation.
Yes, these are my recommendations.
Into the current situation.
You don't need the law. Look at the storage of exhibits. We don't have where these things are stored. You wake up in the morning and the police officers have used them the way they want to use them. So we must check the processes such that we promote more prosecution than persecution. Honorable Sejirinya and Honorable Alan Sewanyana, they were rearrested after being given bail with the conditions set at a cost of 20 million shillings. Now, if you do not understand 20 million shillings, the judge in his wisdom had seen that this is the best that and asked them to deposit their passports. What is very disturbing is that the impunity that is justified by the state and members who work with General Museveni is very absurd, simply because the state had the opportunity to refuse Sejirinya to leave the prison. But because they want their philosophy and ideology of violence is to inflict pain and to create fear, which we have ably, by the way, as a generation now conquered, they arrested them in the most archaic, backward, and brutal way that you can ever talk about in any country. Members of parliament arrested in a style that is very unbecoming.
Wasn't it also surprising to see members of parliament and a lawyer also running away from the police? Wouldn't they just stand, because wasn't it also disturbing?
I have told you, the police works with, there's what they call the joint security meetings. The police works with the prisons, works with the military. Listen very well.
I appreciate.
Now, after court has accorded somebody bail, and the police still finds that there are issues that are going to be settled out in court, they would have asked the prisons.
No, but police told the parliament that they are not the ones who rearrested.
You get the point.
Yes.
And this was a military issue. So there is impunity in this country, and this impunity is geared at, I think, creating anger.
Okay.
Creating anger and the fear. See, Nelson Mandela, creating fear in the public. But Nelson Mandela told us that no one can claim to know a nation unless he has entered all those jail cells.
Thank you so much.
We are alive to that fact.
We have 10 minutes.
And we shall only live with the doctrine of people power, our power.
We have 10 minutes to be out of here. Professor Latigo, our time is running out. Can you just use 2 minutes to sum this up, and we'll hear from you finally?
I'll just ask the president to calm down and recognize the fact that this country belongs to all of us. And if he thinks there are groups that can be heard and is not heard, that is a fallacy. Secondly, elections are over. And the reality that he lost in Buganda and Busoga is a reality that he should just learn to live with it. Escalating this will not work. He's an old man. These young people, every day their numbers and ratios are changing fast in their favor. Time is theirs. So any illusion that you can stop time like they said in the Bible will not work. Leave this issue of bail to courts. If the judiciary will complain about it, create a due process, have analysis of the situation, present statistics to the country, and whatever amendment that you will propose will be understood and accepted. Okay. If you push it because you are a president, you are failing your presidency.
Okay. Well, thank you so much, Professor Gyagenda Semakula. Sarah, in just 2.5 minutes, we're running out of time.
There's an argument that there's a connection between mob justice and bail. Just 2 days ago.
It happened in Barra, I think?
No, just 2 days ago somebody was killed in downtown.
Yes, on Sunday here.
By border riders. In
Rubaga.
Had he been granted bail? 98% of mob justice cases in this country don't reach court. It is people lynched, killed as on the crime scene in
and
most
they also
cases.
qualify for bail.
In most cases. When a case involves violence, the bail guidelines by court, even if in most chances, if the case involves violence, they never grant bail. If they have to, in case they are extreme, exceptional cases, they don't allow the victim, the suspect, to go back to the scene of the crime. Case in point is Mumbai of cases. A case involving violence and you've been given bail, you are not allowed to go back to the place where the crime was committed. So the fraudulent arguments, the dishonest arguments being advanced by proponents of these bail reforms to mislead the public, riding on the lack of information by the public. The other argument is that the people ask that has the justice been done. We cannot legislate for ignorance as a country. In the 21st century, you see leaders arguing that they have to legislate for ignorance instead of educating the people. So my conclusion is, I know NRM has always had their way with the Constitution. When the Constitution gets in their way, they use both man and violence to get rid of the Constitution. Some MPs may be waiting for their envelopes to do the amendment. The citizens are watching. When the dust finally settles, the architects of the draconian laws will be caught by the same laws, and it will be too late to make amends.
Lillian, there we go. We have for 3 minutes to be out of studios. Please use 2 minutes, and I'll just use 1 minute to say good night to the people.
This discussion of the bail, the amendment on the bail issue, is an ongoing discussion. And we have to accept the fact that there is a challenge that has to be addressed. This is not something aimed at addressing only political issues, and I really call upon calmness, call upon further research, and those who want to politicize this should put themselves in the shoes of these vulnerable people who can't afford to pay to access justice. As members of parliament, just like any process of any amendment will be, this will be brought to the floor of parliament. It shall be discussed. We have representatives of the people. All odds of opinion will be accommodated. But whatever comes in, we need soberness. And we don't need to play political comedy or account for donors' money every time when we are discussing something to do with what touches the community. Because everybody in this country matter, and all opinion matter. We don't need to castigate or go personal on anybody. We look at Uganda as a bigger picture than looking at President Museveni as an individual.
Well, I thank you so much. Thank you, Lillian.
Your show funded by donors. You should tell the viewers.
No, here is where we are. Finally, somebody says, why don't you question the release of ministers who were convicted and later released or granted bail? Thus, this call for a constitutional amendment. The laws in Uganda work in verse as long as it is NRM members who are caught in broad daylight and they are released. Bail is not one of the problems of Uganda. We have unemployed, poverty, closed schools, we have Vijambia, we have oppression, we have all the things. These are some of the things that we should be discussing or talking about. We can't exhaust all your comments and concerns. Lawrence Chiwanuka of the Democratic Party left his passport in court and jumped bail in 1995, leaving sureties Henry Ford Mirima and Haji Sebagala behind bars. He was elected DP chairman in the United States as a reward for jumping bail. This is from Tony Joffrey Owana.
But what was he accused of? What was he accused of?
Yes, he has talked.
What was he accused of? Murder or what?
No, he has talked about the shooting.
What was he accused of?
No, but you see the point he brings out is interesting.
Yes.
Court bail has safeguards He had sureties.
Yes.
So when you default on bail,
and I think
no, the citizens need to understand, because people are fronting wrong, fraudulent statistics on people who jump bail. So in case somebody defaults on bail, there are safeguards. Safeguards of sureties,
they're here.
Safeguards of money. So the sureties were arrested because they are guilty.
That case,
no, they are guilty.
It is on statistics.
Yes.
That case was political persecution. It was political persecution.
No, let me find
Henry Ford Mirima and Haji Semagara, and I think
were
Sarah,
arrested, and that's why they are safeguards.
and I think maybe the other thing that we also need to talk about here is that the judicial officers, I think, are not also obliged by law to explain the duties and the obligations to.
Sureties are not in court. In a bail hearing.
We are not just beginning the debate. We are not just beginning the debate.
In a bail process,
we are not just beginning the debate. Ladies and gentlemen, we thank you so much. My name is Gyagenda Semakula. Thank you so much, Professor Gyagenda Semakula, former leader of opposition. Thank you, Lillian Abel, woman member of parliament for Kitgum District, Waiswa Mufumbiro, deputy spokesperson of the National Unity Platform Party, and Sarah Birete. Sitting in here for my brother Charles Odongfo. We just want to wish you the best. We will return next Wednesday for God and my country stabilized, and good night.
It's no secret that ICT makes learning easy.
The strides made in our field could not be possible without it.